Hello friends, welcome to channel and RK this side, and today we are going to discuss a very important topic for different mains examination, that is called public interest litigation. Public interest litigation को हम short form में PIL कहते हैं. PIL has been in news and over the year it has been said that it has helped to deliver justice to everyone, and it has been also credited for democratizing the justice. How it has credited and why it is important for us, we will see in the next few slides. And this is some newspaper excerpts where it has been said that public interest litigations related news, public something like where Supreme Court has cancelled the transfer of 184 Rajasthan plots. It is something serving a purpose of accountability. Similarly, at the same point, there is also issue between this PIL and different courts has raised the concern, especially when it has becoming publicity interest litigations. When someone who want to get addressed and get their name in society, they are using this to serve this purpose. That is also another reason which is saying that government and center is saying that we should do away with the private interest litigation. UPSC and other state PCS examinations has also very frequently asked questions from these sections like meaning of public interest litigation. Just look at this meaning of public interest litigation, circumstances responsible for growing importance, and then also the reasons for growth of role of PIL in ensuring social justice, critically examine the relationship between PIL and judicial activism. So these are the few questions and few sphere where the question has been generally asked, and today we are going to look at this all aspects so that during examinations we will be able to answer or write a good answer. So the basic concepts we should know that the PIL is not indigenous. PIL is have been, you can say that, infiltrated from the other part of world, and during the 1960 USA में इसका विकास होता है, कॉन्सेप्चुअल ओरिजिन होता है, और इंडिया में 90s के दशक में जस्टिस कृष्णा अय्यर और PN भागवती को कहा जाता है कि उन्होंने दे हैव अडॉप्टेड दिस कॉन्सेप्ट ऑफ PIL. कोर डिफिनीशन की अगर बात करें तो इट इज़ अ लीगल एक्शन एक्सक्लूसिवली फॉर पब्लिक इंटरेस्ट. Public interest, what does it mean? Restricting some vehicular movements in an area which is having some more footfall, and that is for some marginalized section, then protecting environments, rivers. So these are some sort of public interest, and that may be solved through the justice. The issue and the main constitutional aspect is that PIL has relaxed the concept of locus standi. So you must be a bit aware that what is the locus standi. Locus standi का अगर मीनिंग अगर आप देखते हैं, वर्बल मीनिंग की अगर बात करते हैं, तो यू कैन से दैट इट इज प्लेस टू स्टैंड, प्लेस टू स्टैंड, प्लेस टू स्टैंड. ठीक है. एंड देयर आर फ्यू कोर रूल्स कहता है कि कोई भी जो जुडिशरी में अगर कोई पिटिशन डालता है अदर देन PIL, that there must be some direct connection. I am telling you, direct connection. He must be suffered some sort of harm, and then there no random outsider should protect error. But this has been relaxed when the PIL evolved, and when the Justice Krishna Iyer, the name which I said, Justice Krishna Iyer, has received postcard petitions directly from prisoners to initiate proceeding regarding the condition of their livings. So this is just a very important fact regarding the PIL, that it has relaxed the locus standi requirements. Then it treat all the petitions as a read petitions. What are the read petitions? Read petitions are given in Article 32, where you have certain reads given to protect your fundamental rights. We say that these rights, and there are 6 rights which have been given, are fundamental rights. Why these are fundamental rights? These are fundamental rights that they are protected by Constitution itself. Constitution itself and Supreme Court and High Courts are protecting our fundamental rights. Supreme Courts under Article 32 and High Courts under Article 2 to 6. So those petitions which are asking for some public interest will be considered as petition under read petitions. एंड रीड petitions का जो होता है फ़ायदा, ये अर्ली सुनवाई हो जाती है इसके ऊपर, 1-2 हेयरिंग तो बहुत पहले हो जाएगी. ठीक है. इट ऑल्सो एक्ट एज एन इंस्ट्रूमेंट ऑफ कॉन्स्टिट्यूशनल अकाउंटेबिलिटी एंड जुडिशियल इनोवेशंस. सो आगे आने वाले आप जजमेंट्स में आप कुछ देखोगे कि यस, दिस इज सर्विंग एज अ वेरी डिफरेंट पर्पस व्हेन जुडिशियरी इज आस्किंग सम क्वेश्चन फ्रॉम गवर्नमेंट्स एंड सेइंग दैट टू डू समथिंग लाइक विशाखा गाइडलाइंस जो है, विशाखा गाइडलाइंस में सुप्रीम कोर्ट ने कहा कि यू मस्ट हैव सम सॉर्ट ऑफ एक्ट्स टू प्रोटेक्ट द इंटरेस्ट ऑफ वर्किंग वुमेन्स. So then they came with an act. So it is some sort of protecting those people who are marginalized where there are no law existing. And there is also an example of judicial innovations. Then we will go through the judgments, we will look at this. Then it democratized the access by allowing third party representation. Disadvantage: who are the third party? Third party are the persons who are filling the PIL behalf of those who are suffering and those who are unable to feel that. Justice must be served to everyone, and that is what the constitution and the democracy is standing for that. So ये जो PIL है हमारे जो डेमोक्रेटिक क्रेडेंशियल्स को है इसको और बढ़ाता है आगे, ठीक है. एंड दैट इज वाई वी आर सेइंग दैट PIL आर इम्पोर्टेंट्स. अगर PIL के टाइप्स की बात कर ले तो देर आर टू टाइप्स. जनरली वी कंसिडर देर आर टू टाइप्स. व्हाट आर दोज टाइप्स? वन, देर रिप्रेजेंटेटिव सोशल एक्शन विच आस्किंग फॉर रिलीफ फॉर ए स्पेसिफिक डिसएडवांटेज क्लास. जैसे कि द फर्स्ट PIL इन योर कंट्री इज हुसनैरा खातून. इट वाज रिगार्डिंग द प्रोटेक्शन ऑफ under trials rights of people who were under trials, right to live free, right to live a good life. So these are related to Husnaira Khatun. And the second is citizens social actions which focus on rights diffusion affecting the broader public. For example, MC Mehta judgment, it is a very important judgment. Roots की अगर बात करते हैं कि what are the basic facts which are joining all the branches of PIL. So basically all those are related for enforcement of constitutional rights. All PIL addresses environments, level and human rights. These are the rights basically which is for public interest एक्सपेंड करते हैं जुडिशियल रेमेडीज को पहुंचाते हैं वैसे लोगों के पास जिनके पास एक्सेस नहीं है. ये इंकरेज करता है एक्टिव NGO एंड सिविल सोसाइटी पार्टिसिपेशन एंड इट्स ऑल्सो प्रोवाइड्स सिस्टमेटिक रेमेडीज बियॉन्ड इंडिविजुअल disputes. So these are the just taxonomy branch of the PIL. What is the shift conventional versus public interest? Conventional versus public interest. तो conventional में क्या होता है कि petitioner, the person who is aggrieved, reach to the judiciary. But here are unrelated third party. Who can be unrelated? As I said, NGO. An NGO can go there. Group of people, those who are standing for someone can go there. Here rights in conventional litigation, rights are enforced privately. If my rights are you can say abrogated, then I will reach to judiciary under Article 32 and Article 226 जो प्रोटेक्ट करेगा. इट विल गिव सम सॉर्ट ऑफ रीच, मैनाडेमस, प्रोहिबिशन, सरसोरी, सो वारंटो. But this is rights which are related to the public. It is not individualistic. It is socialistic. It is for the social. It is for all the people of the society. The nature of conventional litigation is adversarial, but the nature of public interest litigation is collaborative and social. A scope of conventional litigation is limited disputes, individual based, but the public interest litigation is having broad societal impact. Relief: conventional litigation give individual remedy while public interest litigation give relief to the community. For example, a liar can file a PIL for bonded laborers without being labor himself. Now these are the types of questions which is being generally asked, that what is the reason of rise of PILs. So we have certain rights given in Article 21, Article 32. Article 21 is the rights of a life with dignity, and it has been extended over the year. And 32 gives you protection to your fundamental rights. You can approach to Supreme Court. Article 226 give you rights to approach to High Court for protection of your fundamental rights. Second reason for growth of PIL is epistolary. What does it mean? It means that there is no need a physical person to say something. Even a letter, a drafted memorandum or something, a written postcard is enough to consider the point. And that is what the first judgment regarding the PIL was taken, where I said that a postcard given to Justice Krishna Iyer regarding the condition of prisoner's life were treated as a petition, and here the locus standi requirement has been relaxed. Second is the legislation. There are so many progressive law on bonded labor, minimum wages, which is protecting the rights of individual, and these rights are being a source of PIL. Someone who is looking after the people who are suffering approach to judiciary. There are so many NGOs working over this. And the fourth reason which is saying that the democratization via relaxed locus standi, which I already said that the requirements of being harmed, your stand are relaxed. Low cost removal of access to justice. Access to justice is also a reason of rise of PIL. There are low cost removal of socio-economic barriers. These are the challenges which were hindering the penetration of legal remedy to the people, but over the year the rights as well as the people's economic status also grown, and they are now approaching to judiciary for protection of their rights. There are so many NGOs working over this. Media civil society supporting, like labor coverage, the condition of laborers who were working during ASEAN were raised by the media, and rights, expansion of fundamental rights, especially after Article 21, expensive interpretation of Article 21. Though it is also a reason of concern, but that is the serving the rise of PIL purpose. For example, Unni Krishna judgment, which has Unni Krishna judgment has included that education rights of education should be also the part of the Article 21. So anyone who is not getting these rights being enforced by the government can approach to you, Supreme Court and High Courts. Then creativity, judicial creativity and innovative remedies like Supreme Court monitoring Yamuna pollution, giving a living status to rivers. These are the changes which are raising the number of PILs. These are some wonderful examples which has been taken from newspaper, and these newspaper excerpts will tell you that how these judgments of PIL are serving the purpose. The first judgment was 1979. It was Husnaira Khatun, which has established the rights of prisoners. 1982 SP Gupta case, it officially broadened the doctrine of locus standi. So Husnaira Khatun relaxed locus standi requirement. SP Gupta judgment, which is also called thus or first judge's case, whatever, has relaxed the doctrine of locus standi. In 1982, media exposed the labor law violation in ASEAN projects. 1985, Oleg Taili's case recognized the rights of livelihoods. 1987, MC Mehta case, it mandated the closure of polluting industry. 1993, Unni Krishnan said the right to education is a fundamental rights under Article 21. 1997, Visakha judgment addressed the workplace safety. Government implemented Prevention of Sexual Harassment Act 2013. In 2022, State of Jharkhand versus Shiv Shankar Sharma ruled that the bona fide intent of the petitioner must be examined. So this is a curve. This is a curve which is trying to look after rising number of judgment PILs. So basically, what is the benefits of this PIL? Benefits. So first thing, it is strengthening democracy. How? It is ensuring accountability. It is asking questions from governments like pollution-free environments, disclosure of polluting in industries. It ensuring government acts. Government acts. What does it mean? It is like midday meals. The condition of midday meals being exposed. Then it's act as the ultimately constitutional safety valve against executive inaction. If authority is not working, you can reach to judiciary and say that the rights are being abrogated, not implemented. Pillar 2 is saying that it is regarding the voice of marginalized people. How? Husnaira Khatun, human rights of the poor under trials, bonded labor acts, bonded labor rights protected during the ASEAN incidents, and then expanding of horizons like Visakha judgment, environmental protection, MC Mehta judgments where it has to be disclosed the polluting industry. Ultimately, PIL transfers the Supreme Court from a traditional arbiter into a collaborative architect of the social justice. So these are some of the keywords which you may remember during the exam, during the paper, and that it's accountability, democracy, constitutional safety valve, human rights protections. You can add these both examples together. Fundamental rights of marginalized environment protection. But there are some issue. So issue is that there are so many private interest disguised PILs which has been appears motivated, and they are not serving any purpose of people, and this is also creating a huge backlog at judiciary. Like there are so many, around 3,500 PILs pending in Supreme Courts. Governments over the time, center has always said that there must be some sort of restriction. Then courts framing policy instead of law, like Supreme Court monitoring Delhi pollution. So this is a matter of concern that the separation of power has been violated. This is being used for publicity or targeting opponents. We have seen so many, like there are so many PIL person who is who are filling PILs very now and then just to discredit any government of the day. No relief. dissociation of rights instead of declaration without actual remedies. So government, sometimes we have said judgment is just judgment. There is no substantial evidence of any act. Then petitioner hunting for favorable courts, like today they are filing a PIL at High Court, then tomorrow they will reach to Supreme Court. It will give the media limelights and so many things. It may help a NGO to get some credit, get some fund. Resource diversion, time wasted on the frivolous claims like Supreme Court imposing fines in Subhas Kumar. There are so many judgments. Just go through it. अगर आप जस्ट सर्च करेंगे तो आपको मिल जाएंगे. बट ओवर द टाइम हम क्या कर सकते हैं? व्हाट इज द वे वी कैन गेट कीपिंग? व्हाट इज दैट गेट कीपिंग? सो पिटिशनर क्रेडेंशियल को हम वेरीफाई कर सकते हैं, पब्लिक इंटरेस्ट ग्रेविटी को समझ सकते हैं, एंड दैट कैन बी जजेस इन सुप्रीम कोर्ट एंड हाई कोर्ट हु कैन फिल्टर डाउन. इंस्टीट्यूशनल फ्रेमवर्क बना सकते हैं. देयर आर गाइडलाइंस. सुप्रीम कोर्ट हैज गिवन एंड हाई कोर्ट हैज आल्सो गिवन. सुप्रीम कोर्ट हैज गिवन some guidelines that if these are the criteria which meet, then only a petition will be entertained. Rule formation strictly governed by the high courts. Creation of internal screening committee, that is what I am telling you, and heavy penalties on frivolous petitions, demanding strong empirical documentations. Then we can create an ecosystem, community involvement, exhaustive alternative remedies, encourage only NGOs, example POSL petition on food security. So these are the some of the challenges which are associated with the PIL. और PIL के ऊपर हमेशा यही ऐसे ही क्वेश्चंस आते हैं जो हमने भी डिस्कस किया है कि what are the basically why PIL is important. So PIL is important because it is giving a different ascent to different direction to your judgment judiciary. So these are the reasons which are important, which we should consider for a PIL. And at present, especially when there are a large number of under trials and the marginalized section of society are not able to get justice, PIL is an important medium to serve justice to them, and that is what we are stand for. Our constitution, our democracy, and our judiciary stands for that. So this is all about the PIL. If you go through this, you will find very important points like core definitions, what are the types, why it is different from conventional litigation, why there are number of cases PIL is increasing day by day, what are some important judgments which we should consider, that PIL is a very highly impactful in democratizing justice. These are some points, and then the challenges associated with it and the cure reforms. Thank you for being with me. If you find this video helpful, like this, share with your friends and subscribe this channel. Thank you very much.